There's also a provision in this new law. Well, there are a bunch of provisions in this new law. One of them is that in the case where there's a repurchase option and the homeowner now becomes the tenant of the equity purchaser, the homeowner is allowed to have a 30-day right to cure any default under the terms of the lease. So that this is going to prevent the situation where the homeowner is 1 day late in a rent payment and the equity purchaser runs down to the courthouse and files an eviction action to get them out. And that actually did happen. That was a very well publicized case and might be the reason why, you know, that stimulated the legislature enacting this statute. Now the homeowner has rights under this law that they can actually be in default 3 times during the term of this agreement. And each time they have 30 days to cure their default in the rental payment to the landlord. The equity purchaser no longer can just allow the situation to be that, well, the mortgage is there, and so if you pay the payment to me, then I'll see to it that the mortgage gets paid. The law requires that the equity purchaser either completely assume that loan, meaning that they have to actually have an agreement with the lender, and they have actually assumed that loan, or they have to pay the whole thing off. They can't just leave that homeowner's obligation on the books. They can't do that under the law. Another provision of the law is that the equity purchaser has to verify the homeowner's ability to repay the loan in a way, which is what this ends up being called. And in order to verify that the homeowner can repay, the equity purchaser only has to demonstrate that the payments to the equity purchaser and payments on any other personal debt will only be 60% of the gross income per month of the homeowner, which really, actually 60% is a pretty high number of your gross. And so I think the legislature might have made a mistake there. I think so. Another provision of this statute is that the equity purchaser has to comply with the Truth in Lending Act. And for those of us that are dirt lawyers and do closings, we know that Regulation Z is a nightmare. It's very, very difficult to calculate the disclosures, and so that might just stop all that. The final thing that I think is the most important right created under this statute is that when these people are leasing in order to hopefully get back on their feet and repurchase their property in the future, these leases with these options are now being deemed to be mortgages under this new law, so that the new landlord can't run down to the courthouse and file an eviction action. The landlord now has to file a foreclosure action. And the good thing about this particular statute is that it provides a lot of ammunition to the homeowner to defend against that foreclosure action. Because if that equity purchaser didn't follow this law to the letter, and it's hard to do that, they're going to fail in this foreclosure. The law has some teeth in it, in that for every violation of the law, there are civil damages. There is a $15,000 penalty per violation of the law, and the victim could bring the lawsuit, or the state's attorney could bring the lawsuit. So basically, that is it. That is just a very basic overview of that statute, because we don't have a lot of time. But I want to tell you that when it first went into effect, lawyers and real estate agents got very, very concerned, because obviously, really the way the statute is written, it encompasses all foreclosure rescue services, which is sort of what we're doing here. That's what we're doing. And for real estate agents who are involved in short sales, very often they're on the phone with lenders, and they're trying to talk them into allowing a short sale. They've got a buyer that'll buy it, but it's $100,000 short of the mortgage or whatever scenario you have. So real estate agents were very concerned, lawyers were very concerned, and the Attorney General came out with 2 opinions very recently that basically exempt lawyers from this statute, and they also exempt licensed real estate agents so long as the foreclosure rescue services that they provide are not being charged for as a separate charge up front. In other words, if you're a real estate agent and you want to take a listing on a property that you know is going to have to be a short sale because the value is just not there, it's not anywhere close to paying off the mortgage. So long as the only thing being charged by the real estate agent is the normal commission on the sale, then that real estate agent has not run afoul of this particular statute.
Is that also true of licensed mortgage brokers?
That's written right into the statute, which is very interesting because initially when the statute was written, it had an exemption in there for attorneys and for real estate agents, and then when it got rewritten, that got taken out, but the mortgage broker is still in there, so they are exempt. And that's really it. If you have some questions.